wrongly taken into account in assessing the damages. The publication of the same libel on privileged occasions both in the report of a select committee and in the publication of extracts of it in other papers. As to mitigation of damages where the claimant has recovered damages for or brought actions for similar libels, see para.22-244. In Williams v. Mirror Group Newspapers, The Independent, February 12, 1991, ca. This was also applied to articles published after the offending publication. See also Rath v. Guardian News and Media Ltd 2008 EWHC 398, QB 1067. The Defamation Act 1952 S.18, 3, repealed S.6 of the Law of Libel Amendment Act 1888, and replaced it with S.12, cf. Dingle v. Associated Newspapers 1964 AC 371, Lewis v. Daily Telegraph Ltd 1964 AC 234 S.5 of the Law of Libel Amendment Act 1888, which contains provisions for the consolidation of actions for libel, where the publications sued on are substantially the same, was extended by S.13 of the Defamation Act 1952 to cover actions for slander of title, slander of goods or other malicious falsehood. Of amends. 22-245. In any action for defamation, the defendant may give evidence in mitigation of damages that he made or offered an apology. The sufficiency of a retraction of a libel, made without an apology, is a matter for the jury but is unlikely to be sufficient mitigation of damages. 1071. The Australian High Court held in Carson v. John Fairfax and Sons Ltd, Carson v. Slee 1072 that the defendant's failure to publish an apology does not aggravate damages, but in Ranson v. Mirror Group Newspapers 1073 Neil L.J. stated that the relevance of the absence of an apology depends on the facts of the case. Although it is not proof of malice, it can increase the injury to the claimant's feelings, approving Lord Hailsham in Broome v. Castle and Norse L.J. in Sutcliffe v. Pres S. Dirham Ltd 1074. He accepted that the defendant's failure to apologize can be taken into account by the jury when assessing the quantum of damages and refused to regard the trial judge's suggestion to the jury to this effect as a misdirection. An apology must not in itself be defamatory of a third party, as was the case in Watts v. Times Newspapers. 1075 Under S.2 of the Defamation Act 1996, an offer of amends includes an offer to publish a suitable correction and apology. Where an offer of amends has been made, this is likely to count as substantial mitigation. 1076 Also under the new summary procedure, parties. 1071 Pine v. Macmillan, The Times, 1070, SS 8 and 9 of, page 200. In any action for defamation, the defendant may give evidence in, page 200. SS 8 and 9 of the Defamation Act 1996. 1996 provision can be made for a suitable apology. Approving Lord Hailsham in Broome v. Castle and Norse L.J. in Sutcliffe v. Pres S. Dirham Ltd 1074. He accepted that the defendant's failure to apologize can be taken into account by the jury when assessing Ltd 10. He accepted that the defendant's failure to apologize can be taken into account by the jury when assessing the quantum of damages and refused to regard the trial judge's suggestion to the jury to this effect as a misdirection. An apology. Chapter 2. Main Volume. Chapter 22, Defamation. Section 9. Damages. Subsection F. Excessive damages. Excessive damages. 22 to 247. Section 8 of the Courts and Legal Services Act 1990 provides for the Court of Appeal to substitute an award of damages for that awarded by the jury. The Court of Appeal has power to order a new trial on the ground that damages awarded by a jury are excessive or inadequate, or, instead of ordering a new trial, substitute for the sum awarded by the jury such sum as appears to the court to be proper. This power has been exercised on several occasions. 1079 in Ranson v. Mirror Group Newspapers 1080 an award of £250,000 had been made to the claimant, a well-known broadcaster, in respect of a report in the defendant's newspaper. The defendants appealed, on grounds inter alia, that the amount awarded was excessive. Although the practice had been for the court not to suggest guidelines for cases where damages are assessed by a jury for defamation, the Court of Appeal held in Ranson that where it altered awards in defamation cases, the amounts should become guides for later cases. Until such a corpus had been built up, juries should be given guidance, in awarding damages, that they should consider the purchasing power of any award, that the sum should be proportionate to the damage which the claimant suffered and be a sum which it was necessary to award her to provide adequate compensation and to re-establish her reputation. The court in this case concluded that, since the claimant, although entitled to a substantial award, still had a successful career as a television presenter and was highly regarded and respected, the court had power to intervene and indeed ought to do so to reduce the award of damages. It therefore reduced the damages from £250,000 to £110,000. In John v. MGN 1081 the claimant, a well-known popular singer and entertainer, sued the defendant newspaper for libel in respect of a report which described him as chewing his food and then spitting it out at a Hollywood party, a symptom of an eating disorder. It was well known that the singer had in the past suffered from eating disorders and from alcohol and drug dependence which he had overcome. The court accepted that the statement was defamatory and awarded the claimant £350,000 comprising £75,000 damages for the damage to his reputation and £275,000 exemplary damages. The Court of Appeal reduced the sums to £25,000 compensatory damages and £50,000 exemplary damages. The court considered whether the traditional reluctance of appellate courts to interfere with jury awards in defamation cases should be modified in the light of the 1990 Act and the rules made under it, including looking at the claimant's invitation, at the passage in Hansard when the relevant clause was introduced by the Lord Chancellor, and discussed the question of comparisons between awards for personal injuries and those for defamation. Contrary to its dictum in Ranson v. Mirror Newspapers 1082, the Court of Appeal stated that it would no longer be inappropriate to refer the jury to awards in personal injury cases, not as a precedent but to give the jury a sense of proportion as to the appropriateness of high amounts of damages for defamation. Sir Thomas Bingham M.R., delivering the court's judgment, also stated that the trial judge should, in future, be able to indicate the level of award which would be appropriate. Page 202. Overruling jury awards. 22 to 248. In Quia v. MGN 1083, the claimant sued for libel, arising from the publication by the defendants in their newspaper of an article which seriously damaged his reputation as a businessman. There were aggravating features in the defendant's conduct, and the trial judge directed the jury that they could take these into account in awarding damages. He suggested an amount up to £80,000 as a possible sum, but in the event the jury awarded the claimant £105,000. The Court of Appeal, Sedley L.J. dissenting, refused to overrule this award as excessive under S.8 of the Courts and Legal Services Act, on the ground that it was not so excessive that no reasonable jury could have awarded the amount in question. In Campbell v. News Group Newspapers Ltd 1084, the News of the World alleged that the claimant had engaged in homosexual activity with young boys. The jury awarded the claimant £350,000. The Court of Appeal substituted the award for £30,000, and took into account that the claimant had a perverted interest in young boys, that he had attempted to pervert the course of justice by making and procuring false testimony and making damaging accusations against innocent third parties of corruption and lying. In Grobbelaar v. News Group 1085, the Court of Appeal exceptionally overruled the jury's verdict at first instance in favor of the claimant, on the ground that their verdict was against the evidence and that no reasonable jury could have reached it. The House of Lords in turn overruled the decision of the Court of Appeal but reduced the damages awarded to a nominal £1, on the ground that, although the defendant's allegations about the taking of bribes were untrue, his conduct and attitude to the issue made it inappropriate for him to receive more. 1086. Human rights and damages in defamation. Defamation. 22 to 249. 22 to 249. The action for the tort of defamation raises particularly important issues of human rights. Art. 10 of the European Convention on Human Rights provides that everyone has the right to freedom of expression. This right is subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society, and one of the examples of such restrictions in the article is the protection of reputation. In Ranson v. Mirror Group Newspapers 1087, it was submitted for the defendants that the assessment of damages by a jury, without legal guidance, was not prescribed by law as Art. 10 of the ECHR requires. Since it is not provided for in statute and was unpredictable, it was further argued that the award of £250,000 was not necessary in a democratic society as required by Art. 10, since the respondent had not suffered financial loss or social damage. While accepting that the European Convention was not at that time part of English law, the court acknowledged the obligation of the United Kingdom to secure for those within its jurisdiction the rights defined in the Convention, including the right to freedom of expression under Art. 10 and the right under Art. 13 to an effective remedy before a national authority. The court referred to the speech of Lord Gough in ATT Gen v Guardian Newspapers, No. 2, 1088, and deduced that the grant of an almost limitless discretion to a jury in defamation cases failed to satisfy the requirement of the European Convention in that it does not provide a satisfactory measurement for deciding what is necessary in a democratic society or justified by social need. 1089 The court held that awards altered by it in defamation cases should become guides for later cases. This would fulfill the requirement of being prescribed by law, thus no longer being in danger of conflicting with Art. 10. In Tolstoy v. Aldington 1090, the respondent had recovered £1.5 million damages against the appellant for a serious libel, alleging that, when acting as a senior British officer at the end of the Second World War, he had knowingly handed over Cossacks and White Russians to the Soviets, knowing that they would almost certainly be persecuted or killed. The respondent brought a case against the United Kingdom before the European Court of Human Rights, on the grounds that the award of £1.5 million was so high that, page 203, it constituted a breach of Art. 10 of the ECHR. The court upheld the claim on these grounds. While recognizing the legitimacy of the right to reputation, the European Court of Human Rights considered that the award of £1 million, which was 3 times higher than any previous award for libel, offended against the principle of proportionality. In John v. MGN 1091 and in Ranson v. Mirror Newspapers 1092, the Court of Appeal affirmed the consistency of English law with Art. 10 of the ECHR. Proportionality. 22 to 250. In Steele and Morris v. United Kingdom 1093, the ECHR ruled that a damages award of £40,000 made against 2 impecunious litigants and in favour of the McDonald's Corporation failed to strike the right balance between the right of the corporation to defend its reputation as against the defendant's Art. 10 rights. Referring to the requirement under the Convention for an award of damages to bear a reasonable relationship of proportionality to the injury to reputation suffered, the court ruled that the awards were very substantial when compared to the modest incomes and resources of the applicants. The effect of the decision is that the ECHR has now effectively suggested, for the first time, that damages might need to be means tested. Where a large corporate entity sues an impecunious individual, the financial inequality between the parties will have to be taken into account in any award. It remains to be seen how this concept might work in practice in English law, where damages have always been focused on adequately compensating the claimant. This decision and future jurisprudence of the European Court of Human Rights will have an important bearing on the development of the law in relation to damages for defamation. Subsection G. Non-jury awards. Non-jury determinations of damages. 22 to 251. In 1992, for the first time, the size of the award in a libel action was determined by arbitration with the approval of the judge. Popplewell J. sued Today newspaper for alleging that he had appeared to nod off during a trial presided over by him. The parties agreed to arbitration, conducted by the chairman of the Bar Council, to decide the sum which should be awarded to the claimant. 1095 The Defamation Act 1996 introduced a new summary procedure which is designed to reduce the time, expense, and inconvenience of defamation proceedings. Section 8 provides that the court in such proceedings may dispose summarily of the claim if it appears to the court that it has no realistic prospect of success and there is no reason why it should be tried. Under S.8, 3. The court may give judgment for the claimant and grant him summary relief if it appears that there is no defense to the claim which has a realistic chance of success and there is no reason for a trial. Summary relief is defined by S.9 and means any or all of the following. 1. A declaration that the statement was false and defamatory of the claimant. 2. An order that the defendant publish a suitable correction and apology. 3. Damages. The maximum amount specified is £10,000. The court may grant the claimant summary relief if he requests it, but it is notable that the court has the power to order summary disposal without the request or consent of the parties, though the court is not to dispose of the action and grant summary relief without a request from the claimant, unless it is satisfied that summary relief will adequately compensate him for the wrong he has suffered. 1096. 22 to 252. Under the offer of amends regime 1097, following the making of an offer of amends, the judge can determine Determine adequate compensation if the parties are unable to agree the amount. In Cleese v. Clark 1098 QB, the claimant, a comedy actor, sued the defendant. Page 205. Journalist and newspaper for a report stating that he was not funny and that an American tour had not been successful. The defendants published an apology and made an offer of amends, but the amount was disputed. In the event, the claimant was awarded £13,500. In describing its approach to assessment, the court stated that, although the compensation here is not a payment of damages, it should be assessed on the same principles as damages for libel. It stressed that the offer of amends procedure is not the same as summary judgment and that assessment in this context should not be the same as assessment under SS 8-10 of the Act. 1099 in Nail v. News Group Newspapers Ltd. The claimant appealed the judge's determination of compensation under the offer of amends scheme. The judge had awarded £30,000 for defamatory allegations published in an unauthorized biography and serialized in the News of the World. He had done so having found that the defendants were entitled to a discount, which he put at 50% for having made an offer of amends. The Court of Appeal considered that there was no error in the judge's approach and agreed that the use of the regime would lead to substantial mitigation.